Welcome students. Today we are going to discuss about the Air Act, Air Prevention and Control of Pollution Act. The Air Act is the comprehensive federal law that regulates air emissions from stationary and mobile sources. Among other things, this law authorizes EPA to establish national ambient air quality standards to protect public and health welfare and to regulate emissions of hazardous air pollutants. We are going to discuss its introduction, objectives, scheme, salient features, functions of the central and state boards, and then penalties. Now, introduction. The Air Prevention and Control of Pollution Act 1981 was enacted under Article 253 of the Constitution to implement the decisions taken at the United Nations Conference on Human Environment held at Stockholm in June 1972, in which India participated. This is an act to provide for the prevention, control, and abatement of air pollution, for the establishment of boards for conferring on and assigning to such boards powers and functions relating thereto, and for matters connected therewith. This act was introduced and incorporated into the Constitution in 1981, laying down guidelines for the preservation of the quality of air and control of air pollution. The Air Act extends to the whole of India. To counter the problems associated with air pollution, ambient air quality standards were established under this Act. Objectives of the Air Act: to prevent, control, and abatement of air pollution, to maintain the quality of air, to establish boards for the prevention of and control of air pollution, to enable an integrated approach to resolve environmental problems. Now the scheme of this Act. This Act has 54 sections, means dharaएं, and these sections are divided into 7 chapters. Chapter 1 covers Section 1 and 2. Chapter 2 includes Section 3 to 15. Chapter 3 covers section 16 to 18. Chapter 4 includes section 19 to 31A. Chapter 5 covers section 32 to 36. Chapter 6 covers section 37 to 46. Chapter 7 includes section 47 to 54. Chapter 1 contains two sections. Section 1 means short title, extent and commencement. This act may be called the Air Prevention and Control of Pollution Act 1981. It extends to the whole of India. It shall come into force on such date as the central government may, by notification in the official gazette, appoint. In section 2, it includes various definitions related to air pollution. Chapter 2 is related to the constitution of boards. Section 3 and 4 of this act states that the appropriate powers and functions shall be given to the central board and the state boards respectively, and they shall exercise these powers and not go outside the ambit of these powers. Section 5 of this Act explains the constitution of a state board. A person nominated by the state government who has special knowledge and practical experience of dealing with issues related to environmental protection shall serve as Chairman of the State Pollution Control Board. This chairman may be whole-time or part-time. This decision will be taken by the state government. Section 6 states that in case of union territories, the central board shall exercise the powers of a state board under that act, or it may even delegate these powers to any person or body of persons. Section 7 explains the terms and conditions of service of members. A member of a state board constituted under this act, other than the member secretary, shall hold office for a term of 3 years from the date of nomination, notified in official gazette. Section 8 and 9 says about disqualifications, vacations of seat members of members of board. Chapter 10 says about board. For the purposes of this act, a board shall meet at least once in every 3 months and shall observe such rules of procedure in regard to the transaction of business at its meeting as may be prescribed. provided that if, in the opinion of the chairman, he may convene a meeting of board at such time as he think fit for aforesaid purpose. Copies of minutes of meeting under this section shall be forwarded to the central board and to the state government concerned. In section 11, a board may constitute as many committees consisting wholly of members or partly of members. Section 12 states that board may associate with itself in such a manner as may be prescribed any person whose assistance or advice may desire to obtain in performing any of its function under this Act. Section 13 explains about the vacancy in board not to invalidate acts for proceedings. Section 14 states that the member secretary of a state board shall exercise such powers and perform such duties as may be prescribed, like appointment of officers and other employees. Section 15 explains about the delegation of powers. A state board may delegate to the chairman or the member secretary or any other officer of the board, subjected to such conditions and limitations as may be specified in the order, such of its powers and functions under this Act as it may deem necessary. Chapter 3 is related to powers and functions of board. Section 16 lays down the functions of central board. Section 17 lays down the functions to be performed by the state boards. Section 18 states that the central board shall follow the direction of the central government, while the state boards shall follow the direction of the respective state governments. Chapter 4 is related to the prevention and control of air pollution. Section 19 of this Act states that the state government may declare an area within the state as an air pollution area. Section 20 states that the state government may issue instructions to the authority responsible for the registration of vehicles under the Motor Vehicle Act 1939, and such authority shall be bound to follow the instructions. This is done to ensure that the standards of emission prescribed under Section 17 are complied with. Section 21 talks about setting up of industrial plants in compliance and with the consent of respective state boards. It prescribes the procedures for making an application to the board for which a decision has to be made, and intimated to the applicant regarding whether he has permission to set up the plant or not. Section 22 states that no person heading an industry shall emit any excess amount of emissions than the standards set out by the state board. Under Section 22A, when the board believes that there is excess emission being caused by a person running an industrial plant in any air pollution area, then the board can make an application before the court to restrain him from doing the same. Under Section 3, where any emission over the prescribed limit occurs due to an accident or unforeseen event, the person operating the industrial plant shall report about the facts of the same to the state board or any other relevant authorities, to which they shall take remedial action as soon as possible. Section 24. A person authorized by the state board shall have the power to gain entry into any place for carrying out the performance of any of the functions assigned to him. He may examine and inspect any control equipment, industrial plant, record, register, or any other document or object which he has reason to believe was used for the commission of any offence under this Act. In Section 25, it is stated that the state board or any person empowered under it shall have the power to call the person operating such plant or control equipment about any information regarding the type of air pollutant and the amount of emission released by such plant or equipment. It shall also carry out inspection for the verifying the same. Section 26 states that the sample of air or emission may be taken from any chimney, flue, duct, or any outlet as prescribed. The samples shall be admissible in legal proceedings only on the compliance of conditions laid down in Section 26. In Section 27, it is stated that where a sample of emission has been sent for analysis to the laboratory established or recognized by the state board, the board analyst appoint under subsection 2 of Section 29 shall analyze the sample and submit a report in the prescribed format of such analysis. Section 28 states about the establishment of one or more state air laboratories to carry out the functions entrusted to the state air laboratory under this Act. Section 29 lays down for the appointment of analyst with the prescribed qualification for the purpose of analysis of sample of air or emission sent for analysis to any laboratories established or specified under the subsection of Section 28. Section 30 is related to the reports of analysis. Section 31 is related with appeals. Any person aggrieved or having any problem by the order made by the state board under this act may prefer an appeal to such authority within 30 days from the date on which the order is communicated to him. Fifth chapter is related to fund accounts and audit. Section 32 states that the central government can make help to state government financially. Section 33 describes every state board shall have its own fund for the purposes of this act in the form of state government fund, fees, gifts, grants, and donations. Section 33 says a board may borrow money from any source by way of loans or issue of bonds with the consent of or in accordance with the terms of any general or special authority given to it by the central government, or as the case may be, the state government. Section 34 is related to the budget. The central board and the state board shall prepare a budget in respect of financial year next, ensuring showing the estimated receipt and expenditure in the prescribed format under this act. Section 35 states about the preparation of annual report. The central government shall prepare an annual report in prescribed format giving full account of its activities under this act during the previous financial year, and copies of reports shall be forwarded to the central government within 4 months from the last date of previous financial year, and that government shall cause every such report to be laid before both houses of parliament within 9 months of the last date of the previous financial year. Every board shall maintain proper accounts and other relevant records and prepare an annual statement of accounts in such form as may be prescribed by the central government, or as the case may be the state government. Chapter 6 covers penalty and procedures. Under Section 37, whoever fails to comply with the provisions of Section 21 or Section 22 or with the directions issued under Section 31A can be sentenced to imprisonment for a term of 1 year and 6 months. This sentence can be extended to 6 years and with fine if the requisite compliances under the aforesaid section are still not carried out, with an additional fine of 5,000 rupees every day. Under Section 38, penalties for certain acts are laid down. These acts are destroying, defacing, removing, etc. any pillar, post, stack or notice fixed in the ground under the authority of board. Obstruction of any person acting under orders of the board from exercising his powers and functions under the Act. Damaging any property belonging to the board. Failure to furnish information to an officer or an employee of the board which is required by such officer or employee. Under Section 39, any order or direction which has been floated and for which there is no punishment anywhere in the Act shall be punishable with 3 months imprisonment or fine of 3,000 rupees or both. If failure continues, there shall be a fine of additional 5,000 rupees every day. Section 40 of this Act talks about offences by companies. If an offence is committed by a company, every such person shall be deemed to be guilty who is directly in charge of the company, who was responsible to the company for the conduct of its business, as well as the company itself. He shall be punished according to the provision of this Act. Section 41 talks about the offences committed by central or government departments. Where any government department has committed an offence under this Act, then he head to the department shall be liable to proceed and accordingly punished. However, if the head of the department had no knowledge of the committing of these offences or had practiced it due to diligence to prevent these offences from happening, he shall not be held liable. Section 42 states that no suit, prosecution or other legal proceeding shall lie against the government, any officer of the government or any member, employee or officer of the board, where the actions are done by such body or persons are done or intended to be done in good faith in pursuance of this Act. Section 43 states that the court shall take cognizance of only those offences where the complaint is made by a board, any officer authorized under it, or any person who has given notice no court inferior to that of a metropolitan magistrate or judicial magistrate of first class shall try any offence punishable under this Act. Section 44 states that all members, officers and other employees shall be deemed to be acting as public servant under Section 21 of the Indian Penal Code 1860. Section 45 states that the Central Board shall provide information in the form of data, reports or other form of information to the central government. Section 46 involves a bar of jurisdiction. It says that no civil court shall have jurisdiction in any matter which an appellate authority formed under this Act is empowered by this Act to decide, nor should an injunction be granted in respect of any action taken under pursuance of the power of this Act. Chapter 7 of this Act covers miscellaneous part. Section 47 related to the power of state government to supersede state code, not exceeding 6 months. Under Section 48, all the powers, functions and duties of central board or such state board under this Act shall be exercised, performed or discharged during the period of such supersession by the person or persons exercising, performing or discharging the powers, functions and duties of the central board. Under the Water Prevention and Control of Pollution Act 1974 during such period. Section 49 is related to the dissolution of state boards constituted under this Act. Section 50 is omitted by the Air Prevention and Control of Pollution Amendment Act 1987. Section 51 is related to the maintenance of register under this Act shall be open to inspection at all the reasonable hours by any person interested in or affected by such standards for emission or by any other person authorized. Section 52 says about the effect of other laws. Section 53 gives power of central government to make rules. Section 54 gives power to state government to make rules. Now, salient features of this Act. This is the PDF document of this Act.